An Introduction to Constitutional Law, 100 plus Supreme Court Cases Everyone Should Know by Randy Barnett and Josh Blackman.
When is conduct speech? U.S. v. O'Brien, 1968. Texas v. Johnson, 1989. R.A.V. v. City of St. Paul, 1992. The three cases in this topic share one trait in common. Something gets burned. In U.S. v. O'Brien, a draft card is burned. In Texas v. Johnson, an American flag is burned. And in R.A.V. v. St. Paul, a cross is burned. These cases will answer when conduct, such as setting something on fire, is considered speech. Let's start with O'Brien. In the 1960s, all men who registered for the draft received a credit card-sized cardboard certificate. The small white draft card included important information such as the registrant's name, address and birthday, physical description, draft status, and selective service number. Men were required to carry the draft cards at all times. In the days before computers, these physical records helped the government easily identify people who were eligible for the draft. During wartime, it allowed officials to check the status of adult males to ensure that they were not evading the draft by having them produce their cards on demand. Congress made it a federal offense to, quote, knowingly destroy, knowingly mutilate, or in any manner change a draft card. During the height of the Vietnam War, opponents of the war sometimes violated this law by publicly burning their draft cards as a symbol of protest. Solicitor General Erwin Griswold recounted the facts of David Paul O'Brien.
Defendant and three others burned small white cards on the steps of the South Boston Courthouse on March 31, 1966, in the presence of a sizable crowd. An agent of the Federal Bureau of Investigation. I asked him what he had done, what he had burned.
O'Brien answered,
He told me that he had burned a selective service certificate and that he knew it was a violation of federal law, but that he had his own beliefs and his own philosophy why he did it.
At the time, O'Brien admitted that he burned the draft card. He did this, he said, quote, so that other people would reevaluate their positions with selective service, with the armed forces, and reevaluate their place in the culture of today to hopefully consider my position. O'Brien was charged with destroying his draft card. O'Brien's lawyer argued that because the act or conduct of burning a draft card was symbolic speech, it was protected by the First Amendment.
The verbal conduct or symbolic act, or whatever words one chooses to use, on the part of David O'Brien, were intended as an act of dissent, as an act of expression of dissent to government foreign policy, to government military policy, to the war in Vietnam, and to the drafting of young men to serve in that war.
In response, the Solicitor General countered that
Congress did not forbid dissent. It could not do that.
in this case, the government argued, it did not matter whether or not the conduct was symbolic speech.
Congress the power to do what it regarded as necessary and proper in order to carry out its power granted by the Constitution to raise and support armies.
He added,
There was no real impairment of any right to speak, and adequate other avenues of communication were always open to the defendant.
The court ruled against O'Brien by an 8-1 vote. Chief Justice Warren wrote the majority opinion. The court held that even if O'Brien's conduct was, quote, communicative, it does not necessarily follow that the destruction of a registration certificate is constitutionally protected activity. Why not? Here, Chief Justice Warren announced what came to be known as the O'Brien test. Study guide. Can you identify the 4 elements of the O'Brien test? The O'Brien test has 4 prongs. Quote, a governmental regulation is sufficiently justified if it is, first, within the constitutional power of the government, second, if it furthers an important or substantial governmental interest, third, if the governmental interest is unrelated to the suppression of free expression, fourth, and if the incidental restriction on alleged First Amendment freedoms is no greater than is essential to the furtherance of that interest. In O'Brien, the first 2 factors were easily satisfied. Congress had the enumerated powers to manage the Selective Service, and doing so furthered an important governmental interest. With respect to the third prong, O'Brien's lawyer argued that the prohibition on burning the draft card was related to the suppression of free speech.
The only congressional purpose here was the purpose of stamping out dissent.
He argued that the
Congressional action in this case was an act of hysteria rather than an act of reflection, and there was a desire to do something real fast to punish what they considered to be unpatriotic.
the court did not agree. Rather, the majority stressed that the draft card serves a practical purpose. For example, during oral argument, Chief Justice Warren asked,
"Isn't the government entitled to have some knowledge of those facts obtained from the young men in order to effectually administer the Selective Service law?"
The court concluded that the draft card, quote, facilitates communication between registrants and local boards, simplifying the system and benefiting all concerned. Finally, with respect to the fourth prong, the court found that the restriction on symbolic speech was an, quote, appropriately narrow means of protecting the state's interest in managing the Selective Service. Therefore, O'Brien's conviction was constitutional. The distinction between conduct and speech is not very helpful. After all, speech is a form of conduct. The O'Brien test can better be conceived as a way to identify laws that, while they may restrict expressive conduct, they're not designed to regulate the content of speech. Because the ban on destroying draft cards had an important governmental purpose that was independent of the content of the defendant's act of burning his card, the law need only satisfy intermediate scrutiny, which the court found that it had. In our next case, Gregory Lee Johnson burned an American flag during the 1984 Republican National Convention in Dallas, Texas. Kathy Drew, Assistant District Attorney for Dallas County, recounted the facts. A police officer
saw several of the protesters bend a flagpole and remove an American flag. They then handed this flag to Mr. Johnson, who wadded it up and stuck it under his t-shirt. The march then proceeded. The officer testified that when they got to City Hall, he saw Mr. Johnson remove the flag from under his shirt. He tried to light it with a cigarette lighter. It would not light. Someone from the crowd then handed him a can of lighter fluid. He soaked it, ignited it, the flag burned.
Johnson was arrested and was
convicted under a Texas statute which prohibits desecration of the national flag.
Study guide. What difference, if any, is there between burning a draft card and burning an American flag? Hint. What was the purpose of the law banning the burning? The court ruled for Johnson by a 5-4 vote. Justice Brennan wrote the majority opinion. The majority applied the 4-factor O'Brien test. Specifically, the court had to decide, quote, whether Texas has asserted an interest in support of Johnson's conviction, that is unrelated to the suppression of expression. Texas advanced
two compelling state interests. One is the preservation of the flag as a symbol of nationhood and national unity. The second is the preservation of a breach of the peace.
With respect to the second of these interests, the court found that, quote, no disturbance of the peace actually occurred or threatened to occur because of Johnson's burning of the flag. With respect to the first, the court found that the state's concerns about preserving the flag as a symbol of national unity only becomes a problem when a person's treatment of the flag communicates some message. That is, when someone destroys that flag. In other words, the law was aimed at banning the expressive content communicated by the conduct of flag burning. During oral argument, Justice Scalia asked,
"Will you give me an example where somebody desecrates the flag in order to show that he agrees with the policies of the United States?"
He added,
"His motive will never be to honor the country. It'll always be to criticize the country."
In other words, a ban on flag burning will only censor one type of expression, those who are critical of American policies. Not only was the regulation aimed at suppressing expressive conduct, which would give rise to strict scrutiny, but it was actually aimed at particular viewpoints. Viewpoint discrimination is virtually always unconstitutional. The majority concluded that Texas's law was related to the, quote, suppression of free expression. Therefore, the O'Brien test was not satisfied, and strict, rather than intermediate scrutiny, applies. Finally, the majority found that strict scrutiny is not satisfied. The state's interest in preserving the special symbolic character of its flag violates the bedrock principle that the government may not prohibit the expression of an idea simply because society finds the idea itself offensive or disagreeable. Justice Scalia would often cite his vote in Texas versus Johnson as a case where his constitutional views did not align with his political views.
If I were king, I would not allow people to go about burning the American flag. However, we have a First Amendment which says that the right of free speech shall not be abridged, and it is addressed in particular to speech critical of the government. I mean, that was the main kind of speech that tyrants would seek to suppress. Burning the flag is a form of expression.
Our final case, R.A.V. versus St. Paul, involves cross-burning. Justice Scalia recounted the facts.
Just about 2 years ago, in the pre-dawn hours of June 21st, 1990, the petitioner R.A.V., a juvenile, and several other teenagers, allegedly assembled a crudely made cross by taping together broken chair legs. They then allegedly burned the cross inside the fenced yard of a black family that lived across the street from the house where petitioner was staying.
The city of St. Paul convicted R.A.V. of violating the
bias-motivated crime ordinance, which prohibits the display of a symbol which one knows or has reason to know, quote, arouses anger, alarm, or resentment in others on the basis of race, color, creed, religion, or gender.
The lawyer for St. Paul defended the statute.
The First Amendment was never intended to protect an individual who burns a cross in the middle of the night in the fenced yard of an African-American family's home. The historical context of a burning cross in the middle of the night is a precursor to violence and hatred in this country. Given the historical experience of African Americans, a burning cross targeted at a black family under the circumstances outlined is an unmistakable threat. Terroristic conduct such as this can find no protection in the Constitution.
Study guide. Why did the city not prosecute the defendant for trespassing on the private property of the family? If it had, would that law have satisfied the O'Brien test? If so, why? Like the previous two cases, the burning of the cross was an expressive activity. And like in Johnson, The court found that the purpose of banning cross-burning was not unrelated to the expressive activity. Therefore, strict scrutiny applied, and the state must prove that it has a compelling interest in restricting the exercise of this right. All 9 justices agreed that the prosecution violated the First Amendment. However, the court split 5-4 on the rationale. Justice Scalia wrote the majority opinion. He found the ordinance to be
facially unconstitutional because it prohibits speech on the basis of the subjects the speech addresses.
The law only punishes symbols that, quote, arouse anger, not symbols that would arouse happiness, for example. The court explained that
the First Amendment generally prohibits government from proscribing speech or even expressive conduct because of disapproval of the ideas expressed.
Justice Scalia acknowledged that there are
a few limited categories of speech, such as obscenity, defamation, and fighting words, that have traditionally been subject to regulation on the basis of content.
However, these few categories, including so-called fighting words, are not
entirely invisible to the Constitution, so that they may be made the vehicles for content discrimination unrelated to their distinctively proscribable content.
Therefore, he observed,
the government may not regulate fighting words based on hostility or favoritism towards a protected message that the fighting words contain.
He concluded that the St. Paul law
is facially unconstitutional because it imposes special prohibitions on those speakers who express views on the disfavored subjects of race, color, creed, religion, or gender.
Not only was the law content-based, Justice Scalia also maintained that it was viewpoint-based as well.
Moreover, in its practical operation, the ordinance goes beyond mere content discrimination to actual viewpoint discrimination.
Study guide. What is the difference between content and viewpoint discrimination? The majority closed on a somber note.
Let there be no mistake about this court's belief that burning a cross in someone's front yard is reprehensible. But St. Paul has sufficient means at its disposal to prevent such behavior without adding the First Amendment to the fire.
Justice White wrote a concurring opinion, joined by Justices Blackman, Stevens, and O'Connor. They would have declared the statute unconstitutional on narrow grounds. Justice White wrote that a, quote, defendant being prosecuted for speech or expressive conduct may challenge the law on its face if it reaches protected expression, even when that person's activities are not protected by the First Amendment. He maintained that, quote, although the ordinance as construed reaches categories of speech that are constitutionally unprotected, it also criminalizes a substantial amount of expression that, however repugnant, is shielded by the First Amendment. The ordinance is therefore fatally overbroad and invalid on its face. Study guide. What is overbreadth, and why is it of particular concern to the court in a case such as this? Litigants who raise overbreadth claims can assert that their own free speech rights were violated. They can also assert the rights of third parties who are not before the court. In other words, the overbreadth doctrine allows someone whose speech can be prohibited to assert that a statute is unconstitutional. This approach allows the freedom of speech to be robustly protected.